Every year, thousands of completely innocent drivers get pulled over for something as minor as a broken taillight or a rolling stop. The stop should be over in 5 minutes, but then the officer walks back to his patrol car, opens the rear door, and brings out a dog. That animal is walking slowly around your vehicle. It pauses, it sits, and the officer turns to face you with 4 words that most drivers are completely unprepared to hear. The dog just alerted. At that moment, the law says the officer now has the right to search everything inside your car without your permission and without a warrant. Your bags, your glove box, your personal belongings, all of it. And what happens next determines everything. Most drivers panic. They start explaining themselves. They say yes to things they were never legally required to agree to. And by the time that stop ends, they have unknowingly handed away every legal protection they had. This video is going to change that. Because when you know exactly what to do the second that dog alerts, you stop being a victim of a system most people never see coming until it is already too late. Section 1. What the law actually says about drug dogs and your rights. To protect yourself, you first need to understand the legal ground you are standing on, because it contains more protection than most people realize. The foundational case is Illinois versus Caballes, decided by the United States Supreme Court in 2005. The court ruled that walking a drug dog around the exterior of your vehicle during a lawful traffic stop does not violate the Fourth Amendment. The officer does not need your permission and does not need additional evidence of wrongdoing to conduct the sniff. That ruling gave law enforcement a powerful tool that has been used at traffic stops across the country ever since. But the law also draws a hard line in your favor. In 2015, the Supreme Court decided Rodriguez versus United States in a 6-3 ruling. The court held that a traffic stop cannot be extended beyond the time reasonably needed to complete its original purpose. Once the officer has finished writing your ticket and running your license, the stop must end. He cannot legally hold you on the side of the road simply to wait for a drug dog to arrive unless he can point to specific, independent facts, creating reasonable suspicion of a separate crime. That extension of the stop, even by a few minutes, is unconstitutional without that justification. This ruling is one of the most protective legal tools available to drivers at a traffic stop, and the overwhelming majority of people who need it have never heard of it. Section 2. The truth about drug dog alerts that nobody tells you. Here's where things get deeply important, because the public image of drug-sniffing dogs is almost entirely disconnected from what the science and legal records actually show. These animals are presented as near-infallible instruments, highly trained, impossibly accurate, identifying contraband with scientific precision. But researchers at UC Davis conducted a controlled study placing trained detection dogs and their handlers in rooms with no drugs present whatsoever. Out of 144 searches, the dogs produced false alerts in 123 of them. That is not an error margin. That is a pattern of systemic failure. United States Supreme Court Justice David Souter acknowledged this problem directly, calling the infallible drug dog a creature of legal fiction. He cited documented field error rates as high as 38%, with controlled testing showing false positive rates between 12.5% and 60%. Legal briefs filed before the Supreme Court as recently as February 2026 cited research placing false positive rates as high as 80% in some real-world deployments. One of the primary explanations for this is something researchers call handler cue bias. A study published through the National Institutes of Health confirmed that dogs frequently alert not because they have detected a scent, but because their handler is unconsciously signaling them to do so. A slight lean forward, a barely perceptible pause in stride, an involuntary change in breathing. The dog reads its handler, not your car, and that handler's suspicion about you, wrapped in the appearance of scientific detection, is what the law then treats as probable cause to search everything you own. That is a fact that every driver in this country deserves to know. Section 3. The one mistake that costs drivers everything. Here's where most people lose the situation entirely, and they never realize it is happening until long after the stop is over. When an officer says the dog alerted and then asks whether he can search the vehicle, the instinct for most innocent drivers is to say yes. The reasoning feels logical. You have nothing to hide, so refusing looks suspicious. You want the stop to end quickly. You believe cooperation equals fair treatment, so you agree. And in doing so, you erase every constitutional protection you had. The moment you give verbal consent to a search, the legal landscape changes permanently. It no longer matters whether the alert was a false positive. It no longer matters whether the stop was improperly extended. It no longer matters whether the officer had genuine grounds for suspicion beyond the dog. You consented, and in the eyes of the law, voluntary consent is a complete waiver of your Fourth Amendment rights. Every criminal defense attorney who handles these cases will tell you the same thing. Consent searches produce the majority of prosecutable evidence in drug-related traffic stop cases, and the reason is simply that most drivers do not know they are allowed to say no. The second equally damaging mistake is talking. The moment drivers feel cornered, they start offering explanations. They mention a friend who smokes, or something that might be left over from months ago, or that they had no idea what someone else brought into the car. Every one of those statements builds the officer's case against you. The right to remain silent exists precisely for this moment. Use it without apology. Section 4. Exactly what to do the second that dog alerts. This is the section that matters most because knowledge without a clear action plan is useless when you are standing on the side of the road at night. Here is exactly what you do. The very first thing you say is this: "Officer, I do not consent to any searches." Not a softer version of it. Those exact words, said calmly and without aggression. You are not arguing with the officer. You are not obstructing the stop. You are exercising a constitutional right that the Supreme Court has confirmed belongs to every driver in this country. The second thing you do is ask a direct and legally meaningful question. Officer, am I free to leave? That question matters because it forces the officer to either end the stop or formally articulate a legal reason to continue detaining you. Under Rodriguez, he cannot legally hold you simply out of curiosity or vague suspicion. That question, asked on the record, becomes the foundation for a legal challenge if the stop continues without proper justification. Third, stay silent beyond what the law requires. Provide your driver's license, registration, and proof of insurance. Nothing more. You may say clearly, I am choosing to exercise my right to remain silent. That is a protected constitutional statement, not suspicious behavior. Fourth, let your dashcam record everything. Note the officer's name and badge number if visible, the time, the location, and the exact sequence of events. The moment the stop ends, immediately speak your full recollection into your phone while every detail is still fresh. That personal record becomes critical if a legal challenge follows. Section 5. Why the fight does not end when the stop does. If you follow every step above, you have accomplished something most drivers never manage. You have preserved your legal options, and those options carry real and practical power. If the officer searches your vehicle despite your refusal of consent, do not physically resist. Let it happen. What you have created by refusing consent is an undeniable legal record that the search proceeded without your permission. That means the officer's entire authority to search now rests on the weight of the dog's alert alone. And as you now understand, that alert is fully challengeable. A criminal defense attorney can file a motion to suppress, which is a formal request asking the court to throw out any evidence found during the search because the search itself was constitutionally unlawful. Courts examining these motions look at whether the stop was improperly extended to bring in the K9 unit, whether the dog's real-world accuracy rate supports probable cause, and whether the handler's behavior may have cued the alert. Legal analysis published in March 2026 confirmed that evidence discovered after a K9 alert remains one of the most frequently challenged and successfully suppressed categories of evidence in traffic stop cases across the country. Cases built entirely on a single dog alert with no supporting evidence have been dismissed at the suppression stage in courts nationwide. The dog alerting is not the final word on your situation. It is the opening move. And the drivers who understand that are the ones who walk away with their rights intact, their records clean, and their freedom undisturbed. Here's what this all comes down to. A drug dog alert does not make you guilty. It does not give law enforcement unlimited authority over you. And it absolutely does not end your ability to fight back legally. The protections exist. The case law is on your side. But those protections only work when you know them well enough to use them in real time. Standing on the side of the road, in the middle of a stop that just changed direction. That is exactly why this channel exists. Every video published here is built on real law, verified research, and the kind of practical knowledge that makes an actual difference when you need it most. If this video helped you understand something today that you did not know before, please share it. Because the driver next to you on the highway almost certainly does not know any of this either. And if you want to stay informed every time your rights behind the wheel are affected by new laws, new rulings, or new enforcement tactics, subscribe to this channel right now and turn on notifications. What comes next is going to be just as important. Stay with us.